Justice, Honorable Justices, Section 33 can only be invoked in response to a court judgment declaring legislation inconsistent with Sections 2 or 7 of 15. Section 33 cannot be invoked preemptively. To the extent that Ford allows otherwise, it should be partially overruled to prohibit Section 33's preemptive use. Four compelling reasons call for this outcome. First, Ford is contrary to the framers' intent. At Patriation, the Prime Minister and the Premiers who discussed Section 33 all stated that it is a democratic safety valve to be invoked in response to a court judgment. Prime Minister Trudeau said, Section 33 is a way that legislatures have of ensuring that the last word is held by the elected representatives of the people rather than the courts. Today, Canada departs from Prime Minister Trudeau. Saskatchewan Premier Alan Blakeney stated, Section 33 allows Parliament and legislatures to override a court decision which might affect the basic social institutions of a province. Today, Saskatchewan departs from Premier Blakeney. As well, Roy McMurtry, the former Attorney General of Ontario, stated, Section 33 provides a form of balancing mechanism between the legislatures and the courts in the unlikely event of a decision of the courts that is clearly contrary to the public interest. Today, Ontario departs from Mr. McMurtry. These are only three examples from the historical record. The framers clearly intended using Section 33 as part of a charter dialogue with the courts, not preemptively. This court has emphasized the significance of the framers' intent in informing the Charter's interpretation. Constitutional debates preceding the Charter's adoption are essential to correctly interpreting it. This was most recently affirmed in Taylor v. Newfoundland and Labrador. BC Motor Vehicle Act does not displace the importance of framers' intent. What Chief Justice Lemaire rejected is not framers' intent. It was the attempt by federal civil servants to represent the intent of provincial participants in the patriation debates. As Ford clearly departed from the framers' intent, it is partially wrongly decided and must be overruled. Section 33 cannot be invoked preemptively. Ford's legal foundations have also been eroded by this court's subsequent jurisprudence. This is another reason for partially overruling Ford. Ford applied a strictly textual approach in authorizing Section 33's preemptive use. There is no reference to Section 33's purpose or the framers' intent. This is contrary to the purposive approach of charter interpretation. By authorizing Section 33's preemptive use, Ford overshoots Section 33's purpose. This court stated in Stillman that the same core principles that apply to charter rights also apply to the exceptions it contains. Section 33 must be interpreted purposively, which Ford did not do. This court has repeatedly overturned precedents that adopted an overly formalistic method of charter interpretation. The 2025 judgment in John Howard Society cites several examples. Ford is a further example and must be partially overruled. Ford's application also leads to unconscionable results. This is a third reason for partially overruling it. Section 33's preemptive use enables legislatures to systematically deprive Canadians of their rights and freedoms, including in an omnibus fashion. Section 33 was never intended to be used abusively. This is contrary to the Charter's purpose as an instrument of human dignity and national unity. In fact, most of us here today are united in our opposition to using Section 33 in a preemptive manner in Bill 21. This court has repeatedly overruled precedents that generate injustice, especially where this would expand charter protection. Partially overruling Ford would have this precise result. It would also ensure that Canadians are informed that a law is unconstitutional before Section 33 is invoked. Preemptive use makes this impossible. My final point. No legitimate reliance interest can flow from Section 33's preemptive use in the past, including in Bill 21. Overruling Ford to prohibit this practice enforces an undeniable aspect of the constitutional bargain leading to the Charter's adoption. As Ford erred in disregarding it, this honorable court is perfectly positioned to provide the needed correction. Canadians deserve nothing less. Merci, thank you, miigwech.
Thank you very much. Dear